I want to talk to you about office actions received in a patent application. After the application for a patent is filed, the application eventually will be examined by an examiner at the USPTO. When they do so, usually they start with a patent search. They will do a comprehensive patent search, and they will compare the search results with your application. They will try to assess if your invention is truly new. In other words, it meets what we call the novelty requirement, and it's also non-obvious. In other words, even if it's new, the examiner will try to determine if your application and in your invention as claimed in the application meets what is called the non-obviousness test. In other words, the differences between what you did, what you claim to be your invention, specifically by the way the claims are written in the application, the differences between those what is claimed in the claims should be significant when compared with what other people did before you, what other people invented before you, or described or disclosed publicly before you. That analysis is very sophisticated, very complicated, and the examiners will again try to make this analysis and come up with a response as to whether or not the examiner considers your invention truly new and non-obvious and therefore deserves a patent. Sometimes some claims are allowed to go forward and become a patent, and some claims are rejected, or sometimes all the claims are rejected. In either case, the applicant, the inventor, or the applicant, which can be the inventor or the company the inventor works for and so on, or an assignee, will need to respond to that office action. If it's a rejection of all the claims or some of the claims, typically the examiner will have to respond, especially if all the claims are rejected. Obviously, if a response is not filed, the application will become abandoned and everything ends there. Again, a response will have to be prepared and filed, trying to argue with the examiner who examined that application, and sometimes the claims may need to be amended. So the amended claim can be distinguished over the prior art, the patents, the applications, the articles that the examiner found through the search, through the patent search. Sometimes a combination of arguments and amendments have to be submitted to try to overcome examiner's rejection and convince him that you, as the inventor, you deserve a patent in spite of all the other prior art references the examiner found. This is an intense work, requires some time, and oftentimes an interview with the examiner is appropriate. Oftentimes it's easier to convince the examiner, let's say through a telephonic interview, that even though other people may have worked on similar inventions, your invention is still different because of distinctive features which the application may disclose and claim in the claim section of the application. So I would say, when you file for a patent, be ready for such office actions. Unless the claims are very narrowly drafted when you file the application, or unless your invention is truly new and at the peak of its technology it's related to, I would say you should expect these office actions and be ready to respond and be ready to work with a patent attorney so you can overcome that rejection and move the application forward towards a patent. Thank you for watching.